This tutorial is for the Child Custody and Visitation Application Attachment. This is FL-311. This form has to be attached to another document. The choices are attached to the initial petition, attached to the response, attached to a request for order, or attached to a response to a request for order. So if you want to file this document, it has to be attached with one of those other forms. Okay, so let's start here. You'll fill this out by putting in the name of the petitioner. The petitioner is the person who filed first. They will always be the petitioner, and the respondent will always be the respondent. So in the name of a respondent, we'll put in name of person who had to respond to the petition. Okay. Probably there won't be an other parent / party when you're filling out this form. If there is, you will probably know that, so I wouldn't worry about that line of this form in most cases. Speaking of cases, if this is being attached to a request for order or a responsive deck or just a response, you will know a case number and you will have to write your number here. In Siskiyou County, the case numbers are usually 2 letters, then the year, and then the number. For example, if this were a divorce, it would be FL. If you had filed it in 2018, it would be 18-10, for example. So look on any of the existing documents in your case and you will find a case number somewhere. Okay, so we've put in the petitioner, we've put in the respondent, we've put in a case number. Now let's go to the filling out the substance of the form. The purpose of this form really is to give the parties a framework to work in for common visitation schedules as well as common issues that arise in terms of deciding and going forward with custody and visitation. So if you are requesting that the court make an order regarding custody, then check the box for custody. Okay. Whether or not you are asking for a change of custody, you still have to list all of your child's names. So I'm going to put oldest child and middle child and youngest child, just to give you a sense that that's where their names go. And their birthdays will be and you have to put in birthdays for your children. And then it comes to custody. So California has legal custody and physical custody. Legal custody is the decisions about health, education, braces, therapy. Anything that's an important decision is legal custody. It is most common when parents are co-parenting that legal custody be joint. So if you want to share custody, legal custody with the other parent, then write in joint, and then write in joint for your middle child and joint for your youngest child. Physical custody is Where, with what parent do the children live most of the time? So, this will usually just be one parent. However, it could be joint if the child was going to live with each parent half the time. Otherwise, your choices are joint, father, mother, petitioner, respondent, or your name or your ex's name. All of those are choices that you could do, um, so long as it matches what you would like to have happen. Okay, let's scroll down and talk about visitation. It says here parenting time. I like to think of visitation as more of the schedule. So what is the schedule that the children are going to have in terms of visiting with each parent? So we're going to mark the box for visitation. And like I said at the start, this form gives a lot of common choices for visitation, and it's just a matter of reading through the choices um, to figure out what is going to work best for you and your family situation. The initial choice is reasonable right of visitation to the party without physical custody. For example, let's just say that up here it said father. So what this means is that when we're talking about visitation, we're talking about when the children are going to see their mother because the father has primary physical custody. So reasonable right of visitation means that the parent who has custody, we'll just say father in this case, has to act reasonably in making sure that the mother has a chance to see the children. Okay. So if we're not going to have reasonable, we have a choice to have your own attachment. If the two of you sit down and work out an agreement for visitation and custody, you can attach that visitation to this form and ask that the court make your agreement the order of the court. It's great when parents can work together to come to that type of agreement, but it is not necessary. The court system exists to help parents when they cannot come to an agreement. Okay, number C, or letter C. So when you go to court here for an issue regarding custody and visitation, you will be referred to the court mediator. You will have a session with the mediator and then a return to court afterwards to find out if there was an agreement. Box C on this form is if you and the other parent this box is for if you and the other parent choose and pay for your own. You always have the right to hire your own mediator and do your own mediation. That would be completely on your shoulders financially and scheduling. So if you and the other party would like to go to that expense, you may set that up and you may tell the court that you have gone or are going to mediation. Otherwise, if your plan is to go through the court mediation, do not check this box because you will be sent to mediation as part of the whole arrangement. Okay, down to D, no visitation. So let's say that you believe that the other parent is engaged in some sort of behavior that is harmful to your children and you don't want your children to be around that. Mark box D for no visitation. And if the court agrees with you, that means that the other parent will have no right to see the children. If you believe that this would be appropriate for safety concerns, then please check this box. Okay. The next box, E, goes along for some time, and let's work through it together. So, the first thing is to decide who this schedule is for. In our example above, we put in that father had physical custody and that visitation would be with mother. Okay, well, let's change this a little bit and make it a little easier, and we'll make this petitioner has custody and respondent does not. So respondent may get some visitation, but we're going to work on that now. So we'll mark the box for respondent because this schedule is going to be when the respondent has visitation with the children. So your choices are every weekend or alternating weekends or weekdays or other, and you can write in your own schedule there. So let's just say that you want it to be on weekends. So weekends starting, well, figure out when you want the schedule to start. If you're filing this in January, you can ask that it start in February or any other time after that. The court will adjust the start date, but you have to put in something. So let's just say that you'll put in, you wanted it to start January 1st, 2019. Then you get to choose. If you just leave this blank, leave this at weekends, then it means every single weekend the respondent will have visitation with the children. You can choose so that the visitation is only on the first weekend, or second, or third, or first and third, or first, second, third, and fifth, or any combination you want. That's what those boxes are for you to choose if it's going to happen the first weekend, second, third, or a combination thereof. Okay, that becomes important because down here under number 2 you have alternate weekends. So if you mark the first and third weekend, there are some months that have 5 weekends. And if you have a month with 5 weekends, then the respondent, in this case, respondent is the one with the visitation, will only have 2 weekends of visitation because it's only the first and the second, and it turns out there was actually 5. Okay, so that may be acceptable, and it is definitely more clear if the order says first and third weekend rather than alternate, because alternate weekends, it's hard sometimes to remember whose weekend it was to start and whose weekend it should be, and if there are any changes for whatever reason, it's hard to get back on the right schedule sometimes, but you're guaranteed every other weekend is how it's going to work out. Okay, so once you've decided if you're going to do every weekend, first, second, third, fourth, fifth, or some combination, the next thing to do is figure out when the weekend starts for the visitation purpose. Some people like to start Friday, maybe at 6:30 p.m., so around dinner time. Other people like to start their visitation say 6:30 a.m. Saturday, start early the Saturday morning. Either way, you just have to choose when you want visitation to start. It is entirely possible to just say that visitation starts, let's make this Friday, and we'll leave this one blank because we're just going to mark after school. So this would mean that the respondent would pick the children up from school on Friday and then have them until whatever day of the week you agree to. It could be Monday at the start of school, or it could be Sunday at noon. These are all possibilities. You get down here lower, and there are either choices that you can alternate the fifth weekend. Like I said, some months have 5 weekends. This gets a little complicated, but it's there for a reason. If this is the schedule that you and the other parent needs in order to make things work out, then by all means, mark the boxes that make the most sense to you. Those are your choices. For alternate weekends, it's pretty much the same. You'll fill in the date that the weekend starts and the day the weekend ends. Approximate times, unless you're going with start of school or after school. Weekdays, so you can have weekday visitation and weekend visitation in the same order. So for example, let's say that you're going to have visitation from Friday until Sunday on the first and the third weekends. Well, you can also have visitation every weekday. Let's just say it's going to be Wednesday from after school until Wednesday at 9 o'clock. So that means that every Wednesday the respondent will pick the children up, and then the visitation will end at 9. Like I said, other visitation, you're free to write whatever you want. There are a lot of parents who can make it work if the visitation is 1 week on and 1 week off with each parent. If you live nearby each other in the same town so the children can go to the same school, it is possible that on Monday they go to dad's and they're with dad until the next Monday, and then they're with mom until the next Monday, and that goes on, and you can be very flexible. And the more you and the other parent agree, the less the court will just be involved in your life. So it's one of those things to think about is you can agree, or you can just let somebody else make the choice for you. Okay, on to the second page, supervised visitation. So supervised visitation basically means that the party who does not have custody, who is going to have some sort of planned time with the child, has to be supervised by somebody else so that that parent is not left alone with the children. Okay, if you mark this box, then you also have to mark box B and fill in a declaration explaining why why the visitation needs to be supervised, how it is going to be supervised. Okay, so you'll fill out under box C, you request that respondent have supervised visitation. You request that the visitation be supervised by. You can be creative and flexible here if your concern is just that the respondent not be alone. Then you just have to name somebody who would be willing to be there at each of the visits. It doesn't have to be a professional, but it can be. It doesn't have to be a family member, but it often is. It just has to be somebody who will agree to and will actually be present to supervise the scheduled visits. Okay, under E down here, you can allocate the cost of the supervision. For example, if you are going to have a professional supervise visits and the professional is going to charge $100 per visit, you can decide that petitioner will pay 20% and respondent will pay 80% of the um, supervision cost. Okay. Number 4 is where you will set forth who will be transporting the children from each end of the visit. For example, when the visit starts, so that would be transportation to begin the visits. So let's say that the children are with petitioner and petitioner is going to drop them off at respondent's house to start the visit. So then this says petitioner drives them to respondents to start. Now let's say that for whatever reason it's going to be that petitioner is going to pick the children up from the visit, so you can just write in petitioner. Okay, the next thing is that if you need to have a set place where you are going to meet, you can. So for example, you could say McDonald's at 123 Main Street, for example. So you can select a neutral location, or you can say something like respondent's house if you don't mind the exchange being there. The same thing for the end of the visit, wherever the visit is going to end. In this case, since petitioner is picking up and dropping off, then visitation will end at respondent's house. If you and the other parent are not getting along well and there's tension at the exchange, you can mark this one, which basically says that you're not going to go near the respondent and respondent's not going to go near you during an exchange. It's just a matter of picking up the child. Number 5, you can make it so that, or request to make it so that the other party cannot leave either the county or the state with the child. This is much more common in cases where there's a concern that maybe one of the parents will take the child out of state and not return. So if this makes sense to you to have a specific written order, please ask for it. It may or may not be granted, but ask for it. Child abduction prevention is another form that there should be a tutorial for, and basically that form says requires you to say some pretty specific reasons why you think that the other parent might take the child and hide, run off with the child, and some orders to prevent that. You can include a holiday schedule, which is also available online. This schedule breaks down every major holiday and gives you a place to decide who is going to have the child for each of those holidays, or whether there will be an alternating schedule. There are other forms that you can add to it to add to the layers of custody order. These forms are not necessary. In fact, there is no requirement that you fill out this form, FL-311. It's just that sometimes it makes sense to have this form to help clarify what is going on between the parties. And lastly, the generic category for other. If there is something else that you need to ask for that is not encompassed in the body of this form, just write it out there, and then the judge consider it. And that is it for this form.